Yes, Mr. Abbas.
May I please, your lordship? My lord, I have filed the present writ petition challenging the action of the permanent committee.
Now your counter agent of business is over.
Yes, my lord.
So, nothing
Everything
is
is ready, my lord.
Okay.
That is also in the reflected in the list, my lord.
Okay. ठीक है.
No.
Flag 1 or flag 2 say
Just a minute. Let us hear him. Yes, Mr. Abbas.
My lord, I will place the prayer at page 40 of my writ petition. Prayer number 1 is the action of the permanent committee in not sending the name of the petitioner and name of the other applicant advocates to the Honorable Full Court for their consideration shall not be declared as without jurisdiction, being contrary to Rule 6.5 and 6.6 of the Rule 2019.
Sir, can you pause for me a moment? How do you know that the name sent to the court?
My submission is, so far myself is concerned, I entered. Let me place my lord, then I will satisfy.
No, yes, your prayer is specific. That's why I asked this question.
Yes, my lord, because in the first interaction which was held on 17/10 and 18/10/2019, I appeared on 18/10/2019. My lord. Thereafter, my lord, all on a sudden into a judgment of this honorable court came in the earlier writ petition on 10/5/2001 with the direction that all the 48 names, including the 5 who are declared senior on exercise of suo motu power, will be sent for consideration to the full court, and all exercise will be completed by 31st July 2021. Then, my lord, a second interaction was held. I do not under what provision of law, my lord, and in that second interaction, my name was not included. So, my submission is, and only the names that was in the second interaction, only 9 names were sent, my lord. That is the counter affidavit.
Okay.
Then, my lord, Roman IA, the notification of the permanent committee dated 21st/4/2022, annexure 9, for second interaction being without jurisdiction shall not be quashed.
Mr. Bag, just pause for a moment. This one order of the Honorable Supreme Court is here, which was perhaps filed by Mr. Patit Pawan Panda.
My lord, yes.
And
I'm aware, my lord, I have also filed the document, my lord.
In that order, a submission was made on behalf of Justice, of course, SASHIKANTA MISHRA. He was appearing for the High Court at that point of time. He stated an affidavit was filed on behalf of the Orissa High Court, in which it was categorically asserted that the names of all persons, including those who were not recommended to be designated, were also considered by the full court before the final resolution was adopted by the full court.
With the humble submission, that is completely an incorrect affidavit in view of the counter affidavit by this High Court registry in the present case.
We'll go through that. We want to draw your...
Yes, I know, I am aware, my lord. On your lordship's direction, I filed the writ petition, copy, counter affidavit, everything, my lord.
Okay.
Of Patit Pawan Panda case.
Now you come to your prayer portion.
My lord, I am placing that, my lord.
Yes.
Page 40, my lord. Shall I start from the beginning, my lord?
Okay.
Under the facts and circumstances stated above, this honorable court may be graciously plead to admit this writ petition and issue a rule calling upon the opposite part to show cause as to why 1. The committee not sending the name of the petitioner and the name of other applicant advocates to the honorable full court for their consideration shall not be declared as without jurisdiction, being contrary to Rule 6.5 and 6.6 of the Rules 2019. 1A. The notification of the Permanent Committee dated 21/4/2022 by Annexure 9 for second interaction being without jurisdiction shall not be quashed. 1B. The resolution of the Permanent Committee dated 26/4/2022 Annexure 14 also being contrary to Rules 2000 being without jurisdiction same shall not be quashed. Then next page, Roman 2. Further, the sending recommending the names of only 9 applicant advocates, including the opposite part of 4 to 11, by the Permanent Committee to the Honorable Full Court for their consideration for being declared senior advocate shall not be quashed. So also the decision approval of the Honorable Full Court dated 27/4/2022 and the notification dated 27/4/2022 by Annexure 10 shall not be quashed. Then 4. Thereafter, as to why the Permanent Committee shall not to send the names of all the applicant advocates, including the present petitioner and the opposition 4 to 11, making overall assessment giving points as per an appendix B to the Rules 2019 to the Honorable Full Court for being considered by the Honorable Full Court for declaration as senior advocate. These are my prayers, my lord.
So now, so far as this 4 to 11 is concerned, you have fairly stated that.
I have increased my amendment also, my lord. Because but only why I stated so in my prayer person that I should have been considered.
Okay.
For that I have.
All right.
Now, before taking your lordship to the facts of the case, I will take your lordship to the rule first. Annexure 1 is the rule, my lord. Page 43. My lord, prior to this rule, my lord, it is framed as per the Indira Joy Singh case. Prior to that, 2011 rule was there. But after this rule is B, my lord. So sorry, rule 2, definitions. In these rules, unless the context otherwise requires, advocate means an advocate entered in any rule under the provisions of the Advocates Act 1961. B. Committee means the Permanent Committee for Designation of Senior Advocates as constituted under Sub-Rule 1 of Rule 3 of these rules. C. High Court means the High Court defined in Section 2G of the Advocates Act 1961. D. Secretary means the secretary established by the Chief Justice of the High Court of Orissa.
This is important for your case. The rule that yes.
Then my lord, 3 is important because in the counterproof they have said there was transfer and other in the constitution of the Permanent Committee. Permanent Committee for Designation of Senior Advocates. All matters relating to designation of senior advocates in the High Court shall be dealt with by the Permanent Committee, which will be headed by the Chief Justice and consists of 2 senior most judges of the High Court, that is Advocate General of the State of Odisha and a designated senior advocate of the bar to be nominated by the members of the committee. Then, my lord, you will also kindly skip next page 3, my lord, sub-rule 3. The committee may issue such direction the time being as deemed necessary regarding functioning of the secretariat, including manner in which and the sources from which the necessary data and information with regard to designation of senior advocates are to be collected, compliant designated. Then you will also kindly need not place other things, my lord. Rule 6, my lord. That is important for my case. Rule 6, page 45, my lord. 1, sub-rule 1. All the written proposals or application for designation of an advocate as senior advocate shall be submitted to the secretary, provided for that in case of the proposal emanates from a judge, the secretary shall request such advocate to submit form number 2, duly filled in within such time as directed by the committee. 2. On receipt of an application or proposal for designation of an advocate as senior advocate, the secretary shall comply the relevant data and the information with regard to the reputation, conduct, integrity of the advocate concerned, and on the matters covered under several number 2 and 3 of Appendix B, covering a period of last 5 years. 3. The secretary will notify the proposed names of the advocate to be designated senior advocate on the official website of the High Court inviting of Orissa, inviting suggestion and views within such time as may be fixed by the committee. Then 4. After the material in terms of the above is complied and all such information as may be specifically required by the committee to be obtained in respect of any particular candidate has been obtained and the views have been received, the secretary shall put the case before the committee for scrutiny. Then 5. Upon submission of the case by the secretary, the committee shall examine the same in the light of the material provided, and if it so desires, may also interact with the concerned advocate, and thereafter make it overall assessment on the basis of the point-based format provided in Appendix B to these rules. Now 6, my lord, sub-rule 6. After the overall assessment of the committee, all names listed before it will be submitted to the full court along with its assessment report. So now, my lord, so far sub-rule 5 is concerned, interaction is not mandatory. It is optional with the permanent committee, my lord. With the permanent committee, whatever it may be, there is interaction. Then after the interaction, as per sub-rule 6, my lord, all the names should be sent to the permanent committee. To the honorable full court for consideration. Now, at this moment, I will take your lordship to the judgment of this honorable court in the earlier writ petition, where specific direction is given. My lord, current legal reports, 2021, volume 2, CLR, page 1.
You have not given that list.
ଆଗରୁ ଦେଇଛି ଦୁଇଟା କପି ଦେଖନ୍ତୁ ଫାଇଲରେ ଥିବ ଆରଥର ଦେଖିଥିଲି 2021 ଭଲ୍ୟୁମ 2 CLR page 1 କପି ଦେଇଥିଲେ ହଁ ଦୁଇଟା କପି ଅଛି
It's right. What is
Last was half. Last was flat funding. Flat now.
ଏଥିରେ ଅଛି ଏଥିରେ ଅଛି soft copy.
Yeah. My lord, the background of this judgment is, my lord, in total, there are about 48 applicants, advocate applied. And at the stage of sub-rule 2, my lord, only 5 advocates were picked up without taking to the other rules, sub-rules. So that was challenged in 2 writ petition. I filed WPC number 17,009 of 2019 and 3 other advocates filed.
Can you repeat? 48 applied and
48 advocates applied.
Yes.
At the stage of sub-rule 2 of rule 6, the permanent committee picked up 5 names without going ahead to the other sub-rules. That notification calling for views and objections and interaction, that was a challenge. That present opposition
notification for view is not there.
No, that is not dealt with in this.
It is not notified in the notice board.
Nothing was there.
Ultimately, what was held?
It was held, my lord, that the designation of those 5 advocates are discriminatory, but since they have on their part, they will continue till the full court consider their case along with others. That was held, my lord.
Just come to the operative part.
In this case, operating part is paragraph 32 only, my lord. That is
okay.
Paragraph 32, page 17, my lord. Your lordship may kindly turn to Roman 3, my lord. That is for the notification number dated number 1378 dated 19/8/2019. By this, these 5 years declared senior shall have effect till fresh decision by the Honorable Full Court is taken regarding designation of senior advocates on consideration of all 48 applicants, including that of opposite number 5 to 9. Those 5, my lord. Then paragraph 33. The process of designating senior advocates be completed by end of July 2021.
Oh.
Now I will take a lordship to the facts of the case. I filed a debt.
No, you are placing that rule. Anything further you want to place, or we'll just go to the fact? Anything further? Because you are continuing with that rule you placed.
My lord,
rule
6
six.
is difficult matter. My case is that rule 6 has not been complied with, coupled with the judgment of this honorable court in that case, my lord. That is my sole contention, my lord.
Just take pause for a moment. You mean to say that all the names which have been received as per that list, that is to be placed before the
Honorable full court,
full court.
my lord.
There cannot be any discretion lies with
The
permanent committee to exclude any names of
my lord. And that is also to the direction of this honorable court and division bench, my lord, in the earlier judgment that I placed before lordship.
Okay.
Now
So according to you, the notification was not there. First, the notification was not was eliciting the comments from the bar members and people. That was not there. That was one deficit in that. That
and there was also no interaction.
There was no interaction.
No, madam. And that was challenged.
There was no and that was after the Indira Jaising judgment.
Yes.
And still there was no interaction.
No, madam.
Okay. So interaction is it compulsory?
Interaction is optional, my lord.
Optional. So
May.
Then you can't.
They viewed that procedure accepted. But so far other applicants are concerned, notification was issued. Seeking views and
Second notification.
no, first notification, my lord. I am on first notification. My lord, I am at the stage of sub rule 2 of rule 6, they were picked up. So far other applicants were concerned, notification was issued, notice was issued calling for views and suggestions.
Other means the second phase.
No, my lord.
In the same year.
Same. I will take a lordship to the
I understood.
Total number
So means these 5 were just they were earlier they were doing.
Yes.
Right?
Yes.
So when this Indira Jaising was in force, still that was not. It was people like earlier it was being done.
Yes.
Right?
Yes.
Okay.
And that has been set at rest, my lord.
That part is over now.
Over, my lord.
Now come to the issue.
My lord. Now I will take a lordship to the debt chart I have submitted. Though that is a long, lengthy one, but I will place that, my lord.
All the what is the relevant date? All dates are not the same.
my lord. Serial number 2, my lord. That is 2013-14. In fact, that is 5/8/2013. That is also stated in counter affidavit. I applied for being declared a senior advocate as per rule 2011. That remained as it is. Then, my lord, Indira Jaising case came and rule was framed. Thereafter, my lord, by notice, then, my lord.
Just a minute, sir. One doubt. Here you applied in 2013.
Yes, my lord. 5/8/2013.
13. But that time the Indira Jaising was not there.
My lord.
Rule was not framed.
Rule 2011 rule was there. On that rule, I
That
have.
was old rule.
Yes, my lord.
Old rule.
Yes.
So the new rule was not there.
Not there.
So in the new the old rule there was no mandatory the requirement of any interaction.
No, why I am stating, my lord? There is no necessity of interaction.
Yes.
Why I am stating it, my lord? That application, my
But you applied after new rule.
again.
requested it. The committee.
Again you
Yes.
okay.
Yes. Your lordship may kindly
I
see.
thought it was carried forward. That was my impression.
Sorry, my lord.
After that 19 rule came, he was asked
Okay.
to
Okay.
ask for
My lord, your lordship may kindly page 52 and except 2. After the new rule, 2019 rules came into force. After Indira Jaising case, notification was issued inviting application from intending advocates for being declared designated senior. Then your lordship may kindly see page 55, annexure 3. I was directed, sir, inviting reference to your earlier application to be considered a senior advocate. I am directed to send here with a copy of the advertisement number 1 dated 22nd 4 2019 and its annexure with a request to submit your application in accordance with the format prescribed annexure to the court within 30 days for consideration. Accordingly, I applied, my lord. Accordingly, I applied. Then your next page, your lordship may kindly see page 56. Page 56, annexure 4, my lord. There, the advocate who applied, defects were pointed out. And in that list, my name was there at page 59, serial number 30. Page 59, my lord. As per advertisement number 1 dated 22nd 4 2019. Then, my lord, your lordship may kindly turn to next page, that is page 5. I was again directed to remove the defects. Then annexure 6, my lord, page 61. Page 61, my lord. As per rule 6.3, my lord, notification notice was issued inviting suggestion and views. And my name appears in serial number 38 at page 63. Thereafter, my lord, you will also may kindly see annexure 7, page 65, which I have omitted that these 5 persons were picked up at the stage of sub-rule 2 of rule 6 by notification dated 19/8/2019. Then you will also may kindly turn to annexure 8. After the views and suggestion age was sought for, then by the annexure 8 at page 68, notice was issued for interaction to be held on 17/8/2000, 17/10/2019 and 18/10/2019. I appeared in the interaction on 18. My name finds place at page 70, serial number 7. And then the committee was in full strength. Thereafter, my lord, before I forget to place it, my lord. At this moment, prior to this notification, calling for interaction, writ petition was already filed. So after this notification, we filed an interim application before the Honorable Court that the said notification for interaction be stayed. Now at this moment, your lordship may kindly see annexure 15 to my rejoinder affidavit, the order of this Honorable Court. In WPC number, my lord, 17009 of 2019, after this notification of interaction was issued, I filed an application, let it be stayed. In the other writ petition also similar application was filed. Page 19, my lord, rejoinder page 19, that order, my lord. Page 22, that order dated 15/10/2019. You got it, my lord. Had Mr. Bag, who appears in person to move the interim application, the interim application has been filed with a prayer to issue direction for staying of operation of the impute notice dated 3/10/2019. That is annexure 9, my lord. 19. By the annexure 10 to the interim application, the said notice has been issued by the special officer, Special Sir Orissa High Court, Cuttack, to all the applicants who have applied for being designated as senior advocates for their interaction with Parliament Committee on 17th and 18th October 2019. Mr. Bhatt very strenuously argued that if the interim interaction is allowed to be commenced in the midst, the prayer number 1 and 3 made in the application shall become infructuous, or at least the opposite party shall have the opportunity to say that the aforesaid 2 prayers made in the application have become infructuous. Then other things are not necessary, my lord. Your lords may kindly turn to page 24, my lord. The direction. 23 last, regard being head to all facts and submission and especially peculiarity of the facts that process for designating 44 applicants have already commenced. We deem it just and proper to develop the interim application with the following observation. The designation of advocates, opposite party number 5 to 9, a senior advocate shall be subject to result of the application. All the applicants who have been asked to join for interaction with the permanent committee may participate in the interaction without prejudice to their rights, and the contention to be made in the writ application by the petitioner who is also an applicant. Pendency of the writ application shall not be a bar for the petitioner or any other applicant to appear before the permanent committee for interaction. So this was the order, my lord. Accordingly, I appeared, others also appeared. Now, my lord, at this juncture, my lord, although in the earlier writ petition specific direction was issued to complete the process by 31st July 2021, it was not done. But all on a sudden, by the annexure 9 page 71, on 21st for 2022, notice was issued for interaction to 40 advocates. Second notice for the same advertisement, my lord, one of 2019. And here my name did not find place. But prior to this, my lord,
This is dated
this is dated 21st for 2022.
21st for 2000.
Annexure 9 page 71, my lord.
Prior to that, your name, you have been involved for interaction. That is the
Yes, my lord.
that is dated.
18/10/2019.
That is annexure 8.
Annexure 8, my lord.
The same people were called in when you got the chance to appear before the permanent committee.
Yes, my lord.
The same people were here in the 24th. Minus you.
Minus myself, but in addition to
what could be the reason for minus you?
I will take your lordship to that, my lord.
According to you,
my submission is the counter. They have said that although I appeared in the permanent committee on 18/10/2019, but on 23rd 10/2019, permanent committee took a decision to defer my case along with two others, no, without any reason.
because,
And that order is not in the counter affidavit.
because of the case was filed.
My lord,
Because of the
that I do not know.
by the time retribution was filed.
Yes. Retribution I filed, my lord.
Maybe because of that.
No, my lord. Now, before taking your lordship to annexure 9, your lordship may kindly see page 82, annexure 13. After the judgment of this honorable court, dated 10/5/2021, which I have placed before lordship, as per the direction, the 5 advocates who were picked up for being and declared a senior advocate, they were under rule 6(3), inviting suggestion in views. Page 82, my lord, annexure 13. Thereafter, annexure 9 came into force, including those 5 and other 35 advocates, in total 40 advocates.
What about three? What about the other people?
So, like Annexure 13, which was in respect of 5 senior advocates, whether similar notice was issued in respect of the other applicants?
No, my lord. After the first one, 1780 on this only.
So as a rule, it should have been, we mean to say all the people who have applied suggestion, we should have been elicited from the bar.
Done. So for others, that is done.
Done.
Yes.
And
including myself.
Then what is the problem in this then? In Annexure 13, what is the problem then?
My lord, because in Annexure 13, my lord, the problem is these 5% were declared senior advocate by picking up at the stage of sub rule 2.
That's all right. You are not now challenging that.
No, my lord. I am placing this because after the judgment of this honorable court, the notice was issued under rule 6.3.
But in your case also, there was the comments and suggestion invited from the bar. That was not no quarrel. So forget that issue. Now come to the main issue.
Now my submission is now, after this, my lord, the permanent committee issued second notification for interaction, that is Annexure 9, page 71, of 40 advocates.
In which your name does not find place.
No, my lord.
Okay. That is your main grievance.
No, my lord. My grievance is, once the first interaction has not been cancelled for any reason, that is in force. And while that is in force, the second interaction for all is not permissible under the rule.
No, first interaction, when this judgment came,
10/5/2021.
So the first notification is dated 17/10/2019.
For interaction. No, my lord. This is wrong, my lord.
Just let us see that. In which your name also finds place. That is 3rd October 2019.
Yes, my lord. Yes.
3rd October 2019. So I am to say that just come to again once that Annexure 8.
My lord.
This is
page 68, my lord.
Just place it once again.
Designation advocate, senior advocate, Orissa High Court, with reference to the subject cited above, to say that the court are pleased to resolve that all the applicant advocates under the advertisement number 1 dated 22/4/2019 should be requested to submit the material such as reported, unreported decisions, articles and particulars vis-a-vis pro bono activities in order to be considered in the view of decision of the Honorable Supreme Court in India in the case of Indira Joy Singh versus Supreme Court of India, Secretary General and others, so reported such as which are to be furnished on or before 15/10/2019, so that further process can be expedited. It is further resolved that the applicant advocates are to be requested to remain present before the permanent committee on 17th and 18th October 2019 for their interaction with the permanent committee. Therefore, I am directed to request you to submit required materials as detailed above on or before 15/10/2019.
Mr. Bag, the two things it is stated. One is one date fixed for submission of those materials. Another is for your interaction.
My lord.
So did you submit any material?
Yes, everything was.
Now, then the date was fixed to 17/18/2000.
I am in 18.
You appeared before the public.
Yes, that is the contradictory. They have admitted.
You appeared. Then you challenged the matter before the this court in that which was decided by the division bench.
No, my lord. At this stage, not at this stage.
Then
we challenged it when the notification was issued declaring present opposition were 4 to 8. A senior
What happened in between this
it stalled, my lord. It remains as it is.
17, this 3/10/2019,
My lord.
in which you were directed to, or you were asked to appear before the permanent committee on 17th and 18th.
My lord.
And you also appeared.
My lord.
And the other advocates must have also
Appeared, my lord.
Okay. Then whether thereafter no decision was taken.
My lord. No.
Then the next thing came, that was on this Annexure 10. Annexure 9. Again, it is stated, just read it out.
Page 71, my lord.
Yeah.
Designation of advocate, senior advocate regarding interaction as per Rule 6.5. Sir, with reference to the above cited subject, I am directed to say that the court are pleased to resolve that the enlisted 40 applicant advocates copy and close under the advertisement number 1 dated 22nd for 2019 are requested to remain present before the permanent committee on 24th April 2022 at 3 p.m. for interaction afresh.
All right. In this list, your name has been excluded.
Yes, my
So
lord.
let us go to the counter affidavit and see the reason which has been assigned.
My lord, your lordship may kindly see page 8 affidavit, paragraph 21. First.
Page 8, paragraph
21. That is in reply to paragraph 24 of the writ petition.
Please place it.
That the averments made in paragraph 24 of the writ petition being matter of record need no reply from answering opposite party. But it may be stated that the petitioner appeared before the permanent committee in 10/2019 for interaction as per Rule 6.5 of the rules, as there is no order of stay in the matter of designation of senior advocate by the Honorable Court, though the interaction is conducted during pendency of the writ petition number 17,009 and 17,110 of 2019. Thereafter, then important, my lord, thereafter the permanent committee held on 23rd 10/2019 decided to defer the case of the petitioner along with two others.
That means interaction of you was done on 18/10/2019, while these two writ petitions were pending. One of is your writ petition, that is WPC number
17,009 of 2019. 17009 of 2019. It was alone filed by me.
That petitioner. Achha. Any order was passed in that as on say the date 18/10/2019 when you appeared before the permanent committee in as on that date, any order was passed in WPC number 170.
Yes.
What
that is placed in my rejoinder affidavit, my lord. In that writ petition, application of stay of interaction during pendency of my earlier writ petition. There the order was passed that I and other advocates will appear without any prejudice.
That is 15/10/2019. Order passed. Achha. Okay. So that is Anisha, that is 15. Then what they have stated in the counter affidavit, let us come to that.
In the counter affidavit, paragraph 21,
yes,
they have admitted that I appeared. The last sentence of that paragraph, you also may kindly see first paragraph. Thereafter, the permanent committee held on 23rd 10/2019 decided to defer the case of the petitioner along with two others.
Who are the two others?
That is not mentioned, my lord.
Because one writ petition has been filed by you,
and
the other writ petition has been
by
filed
Shantanu Kumar Sodangi, Mr. Acharya, and Mr. Karunakar Jana.
They filed a one writ petition. They were the three were the petitioners.
Three were the petitioners.
Or just WPC 1710 of 2019
was by Shantanu Kumar Sodangi,
Santanu Kumar Solanki, yes.
Sanjay Kumar Acharya,
Sanjay Kumar Acharya, yes.
and Karunakar Jana.
So, then the total number becomes you and those three, it becomes 4.
My yes.
Then these 4 names should have been excluded. If the original list, let us
Yes, my yes.
original list, if it contains 44 names,
No.
if those 4 are excluded, then it comes to 40. So 40 were actually called for that in that second one.
No, including the 5 who are declared. So 35 plus 5.
Okay.
Now,
No, just let us be clear. In that second, when the interaction was called for, whether the names of these persons were included.
yes, my lord, yes.
Santanu Kumar Solanki.
Yes, 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 it is included.
Sanjay and this Karunakar Jana.
My lord.
Names were included in the that second is in 21/4/2020.
My lord. But if your lordship will permit, I will also give their names in this.
Serial number.
Serial number 27, Karunakar Jana, page 74.
Just a minute. Serial number 27. Then Shantanu Solanki and Sanjay Acharya.
Santanu Kumar Solanki, 31, page 75.
Sanjay Acharya.
I am not getting, my lord. I'm looking there. Sorry, my lord. 18, serial number 18.
18.
18, page 74.
Okay. So,
my
commission. This particular we want.
Other names are there.
2 other names. Just.
That is not in. Let me give a copy, my lord. It is not counterfeited. It is not disclosed.
Because we have not disclosed because they are not. Genes are not given, but it was deferred for some reasons which the committee was really on. First page, it is there.
Okay.
Now, on this point, my submission is, my lord.
So, the point, Mr. Patnaik, which Mr. Bagh is raising, that whether at that particular stage the permanent committee had the discretion to leave 3 members. Let us say those 2 are not before us because of this rule which he placed, that is 6-5 na
6-6.
अच्छा ठीक है आउथर 6-6 को पड़े
6-5-6-6 my lord, yes.
6-6 Mr. Because 6-6 makes it very clear that after overall assessment by the committee, all names listed before it will be placed. It's not that suppose maybe the committee may have some adverse remark on any particular applicant. Let us say he has
which probably they don't want to put it on record because it will also affect the reputation of a senior counsel.
No. We are not on that, Mr. Patnaik. What we want to say that let us say that as per this procedure which is there, so you are inviting materials from different sources, then you are also interacting. So after those interaction collecting material, let us say that the permanent committee finds some material against Mr. X, okay, and which according to them that this man should not be is not fit. But in spite of that, the provision 66 says that you are to put up all the names before the full court.
That is
With your, you may give your views that this has come before us, this is the materials, because it is ultimately the full court who is to decide whether, in spite of those objections, the senior advocate
and read 66.
Yeah.
I will also read and expand 3.1. The full court has got a
full court. We are not going.
No. The committees. Committee, my lord, that what kind of power?
Now the question is, committee has the committee any discretion to leave out one name and leave, what is the discretion?
That is, I will be arguing.
Was Mr. Bag placed us today? The entire thing just centers around that very particular. You see
that is, my lord, will be the arguing point is 6.6. Read with 3.1.
Is this 3.1? Let us read that.
What is that 3.1?
3.1 I am placing, my lord. Page 43.
Let me place.
Yes.
Okay. Mr. Bag, please take your seat. Let him answer. You have already placed your. We'll further hear you.
At page 43 of the writ petition,
Yes,
that
yes.
rule starts.
Yes.
I'll take you to rule 3.1, 6.6, and also 10. Okay.
First 3.1. Stop.
Yes. 3.1 is a permanent committee for designation of senior advocates. It starts, my lord, like this. All the matters relating to designation of senior advocates in the High Court shall be dealt by the permanent committee. I stay here, man. And this is not a very small committee. It is a No, I am reading this. I am reading. It consists of the Honorable Chief Justice and two senior-most members of the bar, of the bench, and Advocate General and a co-opted senior advocate, My understanding is to give a purposeful way to give to place the case before the full court. This body has got the power. Also, my lord, that is, I will say, Annex 14, my lord. Annex 14, what I will take, which is impugned, my lord, on that 70% of mark. They have only made a cut-off mark of 70%. Those who have points, those who have got, their names are sent. It is a 9 names were sent. After out of 6 names were selected by the full court. So that is the challenge of my lord. That is the challenge.
But how does the 3.1 will say all these things you said? How one will elicit from 3.1? Because all these things that is beyond the scope of 3.1.
All the matters, my lord. That is
3.1 say who will constitute, who are the people over there. From this, how one will elicit the information that okay, this committee will have this discretion to send and some how come
that is reading the rule as a whole.
Let us be here. If it would have been your case that the permanent committee can only send the names of those persons who have secured 70 above.
Yes, that is Annex 14, my lord. That is,
and Mr. Bar has not secured that mark.
He was not in that particular assessment. His case was deferred.
Right. That is exactly we are telling.
His case was deferred twice. My lord, during the, my lord, I showed you that, and secondly also it was deferred.
So
It is considered and deferred.
it is not your case that on account of this marking, etc., his case was.
I am not privy to that. Only I have to decision. If your lordship wants that, I will get the entire file on Mr.
No. We want to say that, let us say that when these two provisions are there, 3.1 is there and 6.6 is there, and 6.6 says that let us all the names in the list is to be checked before the full court. So if we conjointly read these two provisions, so it may so happen that even though the permanent committee might have given any opinion against a particular advocate to be designated as senior advocate, the full court may, in its wisdom, some more information about the positive side of that particular advocate may come in the full court, and that would outweigh what the permanent committee. So that is exactly the purpose why it has been stated that let all the names be placed before the full court, and it is the full court who is finally to decide. So that means full court decision would obviously override any kind of observation, any kind of thing made. Question is that when you are taking out the names of the petitioner, you are not sending it to the full court for consideration. It is his case that there is infraction of 6.6, and once a procedure has been laid down for designation of if it is to be done, if some lawyers are to be designated as senior advocates, then the procedure which is laid down, it is to be followed in the letter and spirit. It is to be done in that manner.
What permanent committee has done, my lord, he has given it page 83, annex 14.
No, any other method cannot be adopted except as prescribed under
that. That is, my lord, what the permanent committee in his wisdom has done, my lord, annex 14, page 83.
In that case, Mr. Bach's case was not there.
No.
We are thereafter they have done that. That's all right.
Yes.
What about Mr. Bach's case?
Bach's case, my lord, it has been deferred. My lord saw that resolution. I saw, and also another occasion, my lord, on 21st April 2022. His case was also considered. His case was also considered, but deferred. On 21st April 2022 proceeding.
This
is another date, my lord. Twice, my lord. My lord, he is an applicant much before the rules came into force. 1314.
ये जो 23/10/2019 ପରେ
that part of 1314 history, forget it. Now come to the
ଆଉ ଥରେ ତାଙ୍କ କେସ୍ ମଧ୍ୟ ଡେଫର ହେଇଥିଲା ସେଟା କାଇଁ?
It is 21st April 2022, my lord.
But just a minute, let us see your counter affidavit. You have perhaps you have sent only who paragraph आपण place करथले Mr. Bach, paragraph number
I will place 21.
Okay, 21, right.
First paragraph ro last sentence.
23/10/2019 रे गोटे पेपर तापर आउ थरे
नाही page 9 आज्ञा सेही paragraph page 9.
Oh, I see. It is pertinent to the permanent committee held and so and so decided to hold interaction by so and so of the applicant who have appeared on accepting the case of the petitioner. ସେଇଟା କାଇଁ ସେ ଯୋଟା
ଏଇଟା ଆଜ୍ଞା ମୁଁ ପଢି ଦଉଛି page 9 ଲ just paragraph 20 ଉପର ଆଜ୍ଞା ସେ last sentence. Therefore 40 applicant advocates were requested to remain present before the permanent committee for action afresh and the petitioner was not allowed to appear before the permanent committee on 24th April 2022 is because the petitioner case was deferred earlier by the minutes dated 23rd 10 2019.
Oh, the question of citizen.
In the committee, the senior advocate was Mr. B.K. Manthi. He refused to.
It's not like
We are not going to
we
have
are
this.
not, we are not going to that. So by that time, you have already approached this court by filing this
Yes,
petition.
yes, sir. And now, my lord, if lordship will permit, my lord, I will clarify, my lord.
No, let him finish.
My-
I will hear you.
So that second, the first time his case was second time placed before the committee. One of the members recused from that member of the.
Sir, that is not important.
Okay.
Important is why he was
He was deferred.
No, it's-
but not
He was deferred, my lord. That is what I can only say from records, my lord.
No, it's all right.
fine. It's fine.
So my submission is the committee being a apex committee for appointment of the senior designation of senior advocate. Rule 3(1) can be placed into service, saying that they have got a some power not to alter the entire system, but make that 70%, because they not sending the all names, they sent 70% and above points, and that and
All 14 names for 70% and above points.
all, my lord.
If we say now,
My lord, now the next judgment has come. There, the cut-off date is Supreme Court has said in Indira Jai Singh 2.
That is different.
So, my lord,
no, if we say now that let the permanent committee, we are just hypothetical, take a decision on so and so because his case has been deferred.
and now he has been up. My lord, it was listed on 7th, on 8th. My lord and friend has been invited to new format and to that. So his case, my lord, will be considered.
Okay.
Yes, notice has been issued.
Is it correct that you have been again received the notice and
My lord, they have requested me
Ah.
to submit FAS application as per the new rules,
New rules.
amended rules. But that is completely humiliation to me, my lord, because my case is pending. And on case was listed before lordship on 7/8. On that very day, they issued the notice, and there my name was in the first column, but in the second column, one Bansit address, super address is concerned, one Bansidhar Mahapatra was there. Mahapatra of my another district, who is also an applicant. But on the next day, they issued a corrigendum correcting my address.
That is the confusion of harmony.
ଭୁଲ ହେଇଗଲା ସେଠି ବଂଶୀଧର ମହାପାତ୍ର ଥିଲା, ବଂଶୀଧର ବାଗ ଥିଲା, ଦିଟା ପାଖାପାଖି ଥିଲେ.
so now when the date is fixed,
That was directed to be filed within 15 days.
you have given that.
No, man, I have not applied. So my submission is, my lord, they cannot do it at their leisure and pleasure.
That is not the challenge before us.
My lord,
That you have not amended your petition.
my submission is before lordship.
No, so
When the petition is
if they have already invited you and you have choose not to remain not to submit the application, over that you cannot say anything. We have to decide how it is.
I have filed my rejoinder affidavit challenging that, my lord, because in the counter affidavit they have stated so for the first time my writ petition is of 2022.
No. This in the rejoinder affidavit, what you have stated?
I have stated that that is only when my application is pending for consideration, and if there is no law for deferring the particular advocate the rules, if it is deferred, my lord, then my case is after the judgment is delivered, the said decision of the permanent is wiped out because the decision of the permanent committee to defer my case is dated 23rd.
Where have you stated, please? So on the next day, that is page 126, no? Yeah, that page number 17. 8/8/2024.
Paragraph 30 or 16, I have stated in detail.
You have annexed that invitation or the notice?
Yes, my lord. Annexed
Annexure?
To the counter affidavit.
7th August 2020.
Yes. And thereafter 8th August, my lord.
Please,
B/1, page 14.
There you are granted 2 weeks time.
Yes, my lord.
my lord, my counter page 24.
We got it.
And that is because to make my petition infectious.
No. What? Senior advocate, senior counsel, not designated,
But now, my lord, suppose, assuming but not admitting, the permanent committee has the power or discretion to defer my case. And on that is dated 23rd/10/2019. But after hearing of the judgment, after the delivery of judgment on dated 10/5/2021, that is wiped out.
You have checked up that list. I think you are the senior most in that list. Just verify the 20 names are there, na?
ସେଟା ଆଜ୍ଞା ଅଲଗା ସେମାନେ ଏପିଆର କରିସାରିଛନ୍ତି ଆପ୍ଲାଏ କରିସାରିଛନ୍ତି ସେଥିରେ ମୋ ନାଁ ନାହିଁ ଆଜ୍ଞା
ଆଉ କୋଉଥିରେ ଆପଣ ଯୋଉ ଇନଭାଇଟ୍ କଲେ ପରା
ମତେ ସେପାରେଟ ଆଜ୍ଞା 23 ମାଇ ଲର୍ଡ 23
ଯେହେତୁ ସେଟା ଡେଫର ହେଇକି ଯାଉଥିଲା ତାକୁ ଅଲଗା
କିଛି ରିଜନ ଅଛି କି ସେଥିରେ
କୋଉଠି ଆପଣ ନାଁଟା ଆସିଲା କୋଉଠି କହୁନାହାନ୍ତି
24 ଆଜ୍ଞା ଦେଖନ୍ତୁ
24
page 24. The advocates as mentioned below are requested to submit their fresh application as per the new format, that is form 2 of the appendix A of the High Court of Orissa designation senior advocate amendment rules 2023 within 2 weeks from 8/8/2024. Your Lordship, kindly serial number 2 is my name. Then address, Your Lordship, is said Vanshidhar Mahapatra, advocate, Niladri Vihar Street, Fulboni District, Kondhamala. He was also an applicant.
My lord, that we have.
He was also asked for interaction. Then 25, my lord.
That, my lord, we have corrected. That address we have corrected. Correction.
25, they issued the correction correcting the address of mine. Now my submission with my lord, my specific submission before Lordship is that the permanent committee has no power under the rules.
We have noted down that.
My lord. Then, my lord, suppose admitting but not assuming but not admitting that they had the power, then on delivery of judgment on dated 10/5/2021, directing sending of 48 names to the full court, that order, that decision of the power is wiped out. Cannot be said that is in force. And furthermore, my lord, if they intend that the defer will continue for indefinite period, then before issuing the second interaction notice by the next 9, they would have taken a modified order in that disposal before from this honorable court that we have deferred it. So we want to defer each case. They have not done it. So the permanent committee under no circumstances can take the direction of this honorable court in judicial side. They have not done it. Even, my lord, your lordship may kindly appreciate, my lord, the defer decision is dated 23/10/2019. The case, the petition lingered hard. They filed their counter affidavit. they did not whisper a single word that my case is deferred. Not a single word, my lord. And furthermore, your lordship may kindly see, I had the occasion to see that minutes in the earlier writ petition because it was all called for. We are given opportunity to go through it. Order is there, my lord. Now, from the that defer notice, defer minutes, your lordship may kindly see, no reason is there. And there the cut-off mark was fixed 50 points. 50 points. And now, your lordship may kindly see the 24/4/2022 minutes. That is because my deferred on 23rd 10/2019. That's why it is not considered. And furthermore, my submission is there is no provision in the rule for holding a second interaction when the first interaction is in force. When that is not cancelled, that is not cancelled.
All right. Yes.
Now, your lordship has already said the settled position of law. I will place only two decisions of the Honorable Apex Court. One is
Yes.
my lord, year 1975 Supreme Court 915 paragraph 25.
915.
Paragraph 25 at page 918. Well, lordship has already said about the rule. My lord, or not at all.
All right. Yes. That is.
And another decision is also in the same line, my lord. Year 1961 Supreme Court
That is
1527, basing on Nazir Ahmad case, 36 Privy Council. Now,
that number is page number is 252. 36 Privy Council 252. Nazir Ahmad.
235 probably, my lord.
No, 252. Let us. 36. Just see, verify. Let us.
My lord,
Look it up. Nazir Ahmad reference study.
again,
Recapitulate करिए आप. 36 page number
253.
253.
Yes, my lord. 253. Before that, 1800 case has been relied upon, my lord. Now, coming to the notification, my lord, now my submission is, my lord, again assuming that they had the power, the defer cannot be for indefinite period. If it was on 2019, thereafter, my lord, the second interaction has already, second notification is exhausted. Because during pendency of the first writ petition, a second notification was issued. After hearing this, Honorable Court state that Honorable Supreme Court in their writ petition directed that will continue, the second notification will continue after the one is exhausted. And that second notification is exhausted, my lord. Thereafter, again, a third one was issued, that is also exhausted. Wherein some other documents are MISHRA and others were declared. That is also exhausted. Now, but my case remained on defer from 23rd 10/2019 till date. My lord, defer is not, my lord, your lordship, my lord, I am sorry to submit, my lord, when key of Lord Jagannath Ratna Bhandar is opened, why my key was not opened from 23rd 10/2019 till date, my lord? Oh, my lord. Now, my submission is, my lord, now the present writ petition I filed 2022. While pending this writ petition, some advertisement was issued and some advocates have been senior. Now, during 2022 till 17/8/2024, they did not take any step for calling me or to remove the deferred matter of mine. Only on 7/8 when the matter was placed before this Honorable Court.
Another thing just we want to know from both of you, the 2019 rules ସେତେବେଳେ ସେଇ ବେସିସ୍ ରେ ଆପଣ ଆପ୍ଲିକେସନ ଆଉ ବର୍ତ୍ତମାନ ଯୋଉ ଆପ୍ଲିକେସନ ଇନଭାଇଟ୍ କରୁଛନ୍ତି ଆ ଭିତରେ କିଛି ଚେଞ୍ଜ ହେଇଛି କି? ଚେଞ୍ଜ ମାନେ ଏମିତି ରୁଲ୍ସ ରେ କିଛି ଚେଞ୍ଜ ହେଇଛି କି? जोटाकू he will likely to be affected thereby.
No substantial, but I am request to state, my lord.
नहीं जो मार्क फर्क बेसिस रे ये सेकेंड की चेंज
Mark can fix.
ଏବେ ଚେଞ୍ଜ ହେଇଯିବ ଏ ଯୋଉ ନୂଆ ଜଜମେଣ୍ଟ ପରେ ଆଉ ଥରେ ହବ।
से पुराना एप्लिकेशन बेसिस रे यदि तांको केस कंसीडर करिवे वे तो नुआ रूल रे एमती किछि आसी जाइतिबो इज लाइकली टू बी अफेक्टेड मु सेथि पई
Yes.
କିଛି ମାର୍କିଂ ଇଏରେ
अच्छी.
Like the publication, earlier the publication issue was there. You were getting 10.
My lord, so far publication earlier 25 mark points were there. Now it is reduced to 5.
And now they have reduced to
5. My lord.
Suppose somebody has
not to any it's almost
And also power is given to the permanent committee to shortlist the.
permanent committee has got more power now than previously.
My lord, yes, my lord, yes. And to fix the cut-off points. But earlier it was not there. And earlier when I applied, my lord, the decision of your lordship.
ଗୋଟେ କଥା କହିଲି एकदम shortcut. Problem solve କରିବା ପାଇଁ unnecessary.
Then my lord, my submission.
remediation କୁ ପଳେଇ
ମୁଁ ବି ତ ସେଇଆ କହୁଛି।
consider କରାହେବ ଆପଣ
No, my lord, my submission is my if your lordship will permit me, I may not be misunderstood. Now, within the present notification, advocates are there who are not been to school when I joined in practice. I do not want to compete with them.
That is why I say that you are the senior most person.
So I do not want to contest with them. My lord, now I am running 68 years of age and I have completed around 44 years of practice. That is
he's like that always. But ମୁଁ ତାଙ୍କୁ ଦେଖିକି ମୁଁ apply ବି କରୁନି।
ମୋ ଅବସ୍ଥା ଦେଖିକି।
No.
My if your lordship will direct the permanent committee to place my case before the full court, I have nothing to say, my lord. This much, my lord. I do not want to challenge the rules. I do not.
नहीं ସେ rule ଟା ହଜୁର ଆସିନି ଆଗ।
ସେଟା ଆସିନି।
ନାଇଁ ସେ ଏବେ କା
ନା amendment rule ଆସିଗଲାଣି କଣ କହୁଛନ୍ତି?
ଆସିଲା ଏବେ ନୂଆ judgment ଅନୁସାରେ ଆସିଗଲା।
Because suppose what is apprehending, suppose at the permanent committee they may
जो point
କାଟିକୁଟି ଦେବେ ନା ସେଥିପାଇଁ ସେ କହୁଛନ୍ତି। So
ଟିକେ ଦିଅନ୍ତୁ rule ଟା ଆସିଯାଇଛି ମନା କରୁଛନ୍ତି।
ନାଇଁ ମୁଁ
amendment ହେଇକି ଆସିଯାଇଛି।
ମୁଁ ତ ଦେଖିନି ତ।
ଦେଖିବେ ଦେଖିବେ କହିବ
ତମେ ଦେଖିବ ନା ଆଉ।
as per the
ଗୋଟିଏ point ମୁଁ କହିବି rule ରେ if there is any conflict in interpretation, my lord, that there is a power of the chief justice is there at
ଟିକେ ମୁଁ କହିଦିଏ।
is
କୋଉଟା ଅଛି ସେ ଯୋଉ ସ୍କ୍ରୁଟିନି କରି କାଟି ଦେବା ପାଇଁ ଯୋଉଟା
ସ୍କ୍ରୁଟିନି ଆଜ୍ଞା page 2 ରେ
permanent committee ଯୋଉଟା ଆପଣ କହିଲେ
ନା ଏଟା ଇନ୍ଦିରା ଜୟ ସିଂ କେସ୍ ରେ ଅଛି ଆଜ୍ଞା।
ନା ଏ ଯୋଉ ରୁଲ ରେ ସେମିତି ଏବେ ଯୋଉ ଚେଞ୍ଜ ହେଲା ସେମିତି କିଛି ଅଛି କି? କାରଣ ସେତେବେଳେ ଥିଲା ଯୋଉ 66 ଅନୁଯାୟୀ 66 ରେ କି ଚେଞ୍ଜ କରିଛନ୍ତି
66 ରେ
after overall assessment by the committee all names listed to be placed.
No, that is not.
Then tala
এটা May 12 2023 ରେ ଆସିଲା in joining 2
8th December 2023 the amended rules of the Orissa.
So the apprehension that Bartaman जो माने permanent committee may exclude the names that doesn't arise because we are apprehending that what he was Mr. Patnaik was telling that they can shortlist it. So
yes,
shortlist केमती करिवे पूरी provision कौन
आगे करदा provision न थाई कि तो करचंदी करदेले कोन आगे No, my submission is, my lord, my humble submission is, my simple humble submission is that my name may be placed before the court, nothing more, my lord. Okay. So that I do not want that it should be done that there is illegality, there is other things. I do not want that, my lord. And furthermore, my lord, your lordship may kindly see the minutes dated 10.
All right. We'll pass the judgment.
My lord, while passing the judgment,
Just give.
My lord, yes. My lord,
yes. The interpretation, my lord, all question of interpretation of rules relating to interpretation of these rules shall be referred to Chief Justice. That, as in all cases, here is the case where in his single, not as a committee member, he can take a decision on the any interpretation required. My lord.
You want also that Mr. Patnaik should also apply.
Yes. Yes.